Hi, this is Kaushik Ranchod from the Ranchod Law Group, and I want to thank you for joining us on our Q&A immigration session. Today we're going to talk about the Supreme Court's recent ruling on the Defense of Marriage Act. This is fantastic news. Finally, same-sex couples can file for marriage-based green card applications and a host of other applications. In the past, I've had to tell people that we could not file for them even if they were married. And now, this is all changed.
Do I need to be married to my same-sex partner for a green card, or is cohabitation or a relationship of long duration sufficient?
You do need to be married, so you can't just be in a relationship, and that's the same for heterosexual couples as well. For marriage-based green card applications, the basis of these applications is the marriage itself. So even if you are living together for years, you still must be married. But now you are able to get married depending upon the specific state that you live in.
What if I live in a state that does not allow same-sex marriage? Do I have to move?
You don't need to move, and this was just recently put out by the USCIS in a memorandum. You don't need to move, but you do need to marry in a state that does allow for same-sex couples.
Where can I get married?
You can get married in California, Connecticut, Delaware, Iowa, Maine, Maryland, Massachusetts, Minnesota, New Hampshire, New York, Rhode Island, Vermont, and Washington, D.C. and Washington. So if you live in one of these states, or if you don't live in one of these states, for instance, let's say you live in Georgia. Well, that's not a state that unfortunately allows for same-sex marriage, but you could travel to California, have a nice vacation in San Francisco, get married, and then you can move back to Georgia and apply.
After getting married, what is the first step to petition for a green card for my spouse?
You need to collect all of your documents demonstrating that you have a real relationship. So some of these documents, if you have them, that you would collect are, for instance, a lease, joint bank accounts, photos. And those are documents that you would take to the interview. Then, of course, you have to complete the marriage-based application. Some of the forms include the I-130, I-485, the G-325, the I-131, the I-765, and, of course, all of the supporting documents that go along with that application.
If I am a U.S. citizen or lawful permanent resident in a same-sex marriage to a foreign national, can I now sponsor my spouse for a family-based immigrant visa?
Yes, you can file a petition, so just the same as you would for a marriage-based green card application known as the adjustment of status in the United States. You can also file, for instance, an I-130 for what's known as an immigrant visa, where you would file the I-130 petition in the United States, and then they would complete the process of filing at the U.S. Embassy.
If I am a U.S. citizen who is engaged to be married to a foreign national of the same sex, can I file a fiance petition for him or her?
Absolutely. So this also applies to fiance visa applications. And here, what you would do is you file the fiance visa petition. You'd file the I-129F at your appropriate service center. So, for instance, if you lived in California, you'd file at the California Service Center. It depends on where you live, of course, at what service center that you file. After that petition's approved, then it goes to the National Visa Center, and they do background checks. And then it goes to the specific embassy where they would apply for the visa itself, and then they would have to enter and marry within 90 days with you, and then you guys would apply for the marriage-based green card application.
My spouse and I were married in a U.S. state or foreign country that recognizes same-sex marriage, but we live in a U.S. state that does not. Can I file an immigrant visa petition for my spouse?
Yes, and this is a new policy that the Obama administration has just come out with, and we're grateful for this clarification. So even if you do not live in a same-sex marriage state, you can still apply as long as you have a bona fide marriage and you married in a state that allows for same-sex marriages.
Do I have to wait until USCIS issues new regulations, guidance, or forms to apply for benefits?
That is another excellent question. I want to thank you for that question. No, you can apply right now. And in fact, we're already preparing applications. This also applies to waiver applications as well. So for instance, if you have a situation where your spouse entered with out inspection, and you're eligible for what's known as the I-601 waiver, hardship waiver. You could also apply for this based on your marriage as well. So I invite you to contact us. You can reach us at 916-613-3553 if you have more questions, or you can email us at info@ranchodlaw, and we'd be happy to discuss these issues with you in further detail. I want to thank you so much for taking time to listen to our Q&A, and we look forward to seeing you next time.